Okay, so good evening, everyone. And my name is Attorney Robyn McCoy, and I am the president of Black Women Lawyers in Michigan. And I am glad that you're here to join us for this expungement training. We are honored to have our Assistant Attorney General, John Pallas, with us, as well. We have some of our board members here to talk about the Clean Slate legislation, and then I will talk about the actual expungement process, and then we'll open it up for a Q&A. This is being recorded. We're asking that you mute yourself during the presentations, and then you can unmute yourself once we start doing the Q&A. So at this time, I'm going to turn it over to, we have our wonderful moderators, but I'll start with our Vice President, Attorney Delicia Coleman, to do introductions.
Good evening, ladies and gentlemen. Thank you for joining us. I'm Delicia Taylor Coleman, and I am Black Women's Law Association current Vice President. And we thank you so much for joining us in this expungement training. First, I'm going to introduce John Pallas. He currently serves as Michigan Attorney General, Assistant Attorney General. I'm sorry, hold on. I'm going to have to get my glasses. Just a minute. We're going to make do. Currently serves as Michigan's Attorney General under Dana Nessel's first assistant for the appeals section of her Criminal Trials and Appeals Division. John is the frontline supervisor for the division's federal, habeas, state appeal, and expungement practice areas, and therefore that's why he's joining us today. Thank you. And the latter of which constitutes one of Attorney General Nessel's key initiatives. John regularly participates as a lecturer or panelist in trainings and seminars involving these practice areas, particularly in the expungement area. John has served as an Assistant Attorney General for the past 11 years and previously served as an Assistant Prosecuting Attorney for the Office of the Oakland County Prosecuting Attorney Office. For over 21 years, he was appointed chief of that office's appellate division in 2008, and a position he held until he joined the Department of Michigan Attorney General. Thank you, John.
Thank you, everyone, and good evening and welcome. My name, as was indicated, is John Pallas, and I'm one of Dana Nessel's Assistant Attorney Generals here at the Michigan Attorney General's Office. I do have a PowerPoint that I'm going to be using, and hopefully when I do share screen, it'll work. I tested it out previously. What I'm going to be doing is focusing on the law itself, the Clean Slate Act, kind of giving some context to it by talking about some of the prior versions of the statute leading up to it, as well as some of the key features of the Clean Slate legislation of 2020. So without further ado, I'll go ahead and share my screen. And I'm going to start the slideshow. Okay, can everyone see that?
Nope, no, we cannot.
No, okay. Let me try this again. How about now?
Yes, we can.
Okay, excellent. Thank you about the little technical problem there. Again, welcome everybody. There were some substantial changes to the expungement laws that went into effect on April 11th of this past year. I'm going to do my best tonight to give some advice on these new laws and how they will impact expungement practice in the state of Michigan. I'm also going to discuss some additional changes that are coming to the expungement laws, both in 2022 as well as into 2023. Just a quick disclaimer that statements made in this presentation are my own and not intended to necessarily reflect the views, opinions, or position of the Michigan Attorney General or the Michigan Department of Attorney General. Okay, starting off, I think to understand what a great thing and what a great series of statute the Clean Slate Act provides, you need to go back and take a look at what expungement was like when it first came about. And expungement was first passed into a law back almost 60 years ago, back in 1965. However, the very first expungement statute allowed one and only one conviction to be set aside after a waiting period of 5 years. As this statute was introduced in 1965, felonies with a punishment of up to life and traffic offenses could not be expunged. If an applicant had a criminal convictions, even convictions under the motor vehicle code, for example, driving while license suspended, the applicant would be barred from setting aside any conviction. So it was a pretty high bar, pretty much one. You get one free pass, in other words. At the time that the statute came out, applicants were required, and in fact, they still are required to demonstrate that their conduct since the date of the conviction warranted granting an expungement. That's always been a part of the statute and continues to be part of the statute, except when we talk about expungement, automatic expungements, which will be coming fairly soon. The statute as it existed pretty much was the way that it was, with one conviction and that's it, up until 2011, where the amendments that were made to the statute at that time said that someone who's otherwise eligible to expunge to expunge an application, that should be conviction, not to be rendered ineligible by the presence of not more than 2 convictions for minor offenses. Yeah, you could not expunge those minor offenses, but they were not a bar to expunging a greater offense. In other words, if you had a felony and 2, what was called back then, 2 minor offenses, you could still get the felony expunged, although you couldn't get the minor offense expunged. Minor offense back then in 2011 meant a misdemeanor or ordinance violation. The practical effect of this statute is that many applicants were still prohibited from expunging their convictions, limiting the definition of minor offense to misdemeanors with a permissible maximum of 90 days incarceration, left out a whole slew of misdemeanors in Michigan, many of which are 93-day misdemeanors, and it caused a problem for a lot of applicants. Offenses like simple assault and battery, a very common offense, were thus excluded under this amendment. And the limitation that misdemeanors were committed when the applicant was no more than 21 years of age prevented many others from taking advantage of this particular amendment. So 2011 was the first time amendments were made to the statute, but they were not all that great. Then we moved ahead to 2014. It left the basic structure of the expungement statute intact, but added some provisions, some good for applicants, some not so good. What was the good parts of the 2014 amendments? It made it so that a person with 1 felony conviction and up to 2 misdemeanor convictions, regardless of the potential punishment, could expunge all 3 convictions. It also included a provision for the very first time that allowed victims of human trafficking to expunge certain convictions. For example, prostitution, if the victim could show that the conviction was a direct result of his or her being a victim of human trafficking. The bad part of these 2014 amendments, they added a number of offenses to the list of non-expungible convictions. So all of a sudden now, instead of just having offenses that life offenses and traffic offenses, we got things like child abuse, felony domestic violence, trafficking, 4th-degree criminal sexual conduct, and made it clear that any drunk driving offenses as a category of traffic offenses were non-expungible. So it actually added to the list of things that were not expungible. The amendments also added a provision in 2014 that indicated that if an application is denied by a court for any reason, and that could mean the person forgot to sign it or forgot to notarize it, the applicant was not able to apply for 3 years unless the court stated otherwise. So good parts to this 2014 amendments and some not so bad, not so good parts. That brings us to 2020 and the 2020 amendments to the expungement statute, which is commonly known as the Clean Slate Act. In 2020, Governor Gretchen Whitmer, excuse me, signed into law the Clean Slate Act, significantly changed expungement law and procedure in Michigan. And how did it do so? First of all, it expanded the number of felonies and misdemeanors that can be expunged. Excuse me. Expanded the types of offenses that can be expunged, most significantly traffic offenses. Created the so-called one bad night provision for combining separate but related offenses into one offense for purposes of counting convictions. Adjusted the statutory waiting period to consider the type and number of convictions sought to be expunged. Allowed for the expungement of misdemeanor or ordinance marijuana convictions for past conduct that is now legal. And finally, the Clean Slate Act mandated a system of automatic expungements. In other words, meaning that there would be no application required that will likely go into effect in 2023. And we're going to go over each of these briefly to kind of explain how these statutes and the Clean Slate Act and its various provisions apply. These new laws are significantly, and I mean very significantly, it should say, broader than prior versions of the statute, meaning that many more people in the state of Michigan are now eligible to have their convictions expunged. I saw an article in the Free Press earlier this year, which estimated that several 100,000 to as many as 1 million people are now becoming eligible to have their convictions expunged. I mean, that's explosive. And that's a lot more people that have the potential for expungements to be granted and for people to have it start over with a clean slate, so to speak. One of the problems that has long been in effect there was a study that was done out of the University of Michigan a couple of years ago, which indicated, and this is actually a kind of a sad statistic, that about 93 to 94% of people that are eligible to have convictions set aside or expunged don't do it. And either they don't know how to do it, don't know about it, don't feel like they have to have an attorney to do it. There's a whole lot of reasons. And actually, there's been a lot of good publicity about expungements. This year in particular, there's been a great uptick in expungement fairs. So a lot of people are being able to take advantage of the Clean Slate Act because it's wonderful to have all these laws in effect. But if people aren't taking advantage of them, not a good thing. Now, the Clean Slate Act still lists a bunch of convictions that cannot be expunged. Among them are any offense where the potential punishment is up to life imprisonment. That would be offenses like second-degree murder, first-degree criminal sexual conduct, kidnapping, second-degree child abuse, child sexually abusive material or activity offenses, some offenses involving the use of a computer or the internet, second and third-degree criminal sexual conduct, assault with intent to commit criminal sexual conduct. All these offenses are still prohibited from being expungement, even under the Clean Slate Act. Fourth-degree criminal sexual conduct is now prohibited if the offense occurred after January 12th of 2015. So conversely, offenses that occurred before 2015, January 12th of 2015, can be expunged. Now, while the vast majority of traffic offenses can now be set aside under the Clean Slate Act, and I mean, this is big, the fact that the Clean Slate Act came into being and decided that the legislature and the governor decided to include traffic offenses, because before there was a categorical bar. Somebody could set aside a conviction for felonious assault, but they couldn't set aside a conviction for driving while license suspended. And that just didn't make a lot of sense. And I think the legislature did a great job in thinking about how they could do this. However, there's still a few traffic offenses that cannot be set aside. Operating while impaired offenses, although this is about to change in Michigan, as we're going to talk about in a couple of minutes. Committing a traffic offense as a person with commercial driver's license, operating a commercial vehicle, and any traffic offense that involves death or injury. That would be, for example, if you hit injure or hit a worker that's working on the highway and you get charged with a traffic offense, that cannot be set aside. One thing about the Clean Slate Act that it's important to remember when you're dealing with clients is, and I'm not sure if this was intentional or whether what the thinking was exactly behind this, but when they get expunged off of somebody's criminal history, these traffic offenses, the Clean Slate Act specifically provides that an order setting aside a traffic offense does not require the Michigan Secretary of State to remove the offense from the applicant's driving record. So knowing that is important because you want to tell your client, that, hey, maybe your insurance company may still be able to see that you were convicted of certain traffic offenses. It may no longer be on your criminal history, but it's going to still stay on your traffic record for as long as they're supposed to be on your traffic record. So that's a little weird quirk about traffic offenses. But all in all, we went from having no traffic offenses being able to be set aside to the vast majority of them being able to set aside and be expunged. Other kinds of offenses that can't be expunged, felony domestic violence, if there's a prior misdemeanor for domestic violence, human trafficking offenses, terrorism related offenses, convictions for attempt to commit any of these offenses. So, the Clean Slate Act didn't broadly say everything can be expunged. I mean, there's still a whole slew of convictions that cannot be expunged, but now they're pretty much the most serious offenses that cannot be expunged, rather than just lots of them that used to be able to be expunged or not be able to be expunged, excuse me. Now, another great thing that the Clean Slate Act did was and remember, when we were talking about the original 1965 statute, it basically said you could expunge one and one conviction only. If you had two, even if they were misdemeanors, you couldn't set anything aside. What the Clean Slate Act has done is has expanded things. It says that no more than 3 eligible felonies can be expunged. In other words, up to 3 eligible felonies can be expunged. The law does indicate that having a 4th felony conviction will categorically bar the applicant from expunging any convictions. So, we went from having only 1 felony that could be expunged. Now we are up to 3. That can even be expanded further when we talk about the one bad night part of the statute, which has been allowing a lot of people to get expungements who would otherwise have 4, 5, 6, 7, 8 felonies on their record. And I'll explain how that works momentarily. Interestingly enough, the statute does not seem to count convictions that occurred outside the state of Michigan. So in other words, the way the statute's phrased is, it talks about not more than 3 convictions in this state. So I would say that does not include convictions from other states. When you're counting how many convictions somebody has, you only count convictions that occurred within the state of Michigan. Arguably, that would include federal convictions if they occurred in the state of Michigan. So that's something kind of new that wasn't in the statute before. There's also a limitation on the number of assaultive crimes that can be set aside. That's limited to 2. Not more than 1 conviction can be for the same offense that is punishable by more than 10 years in prison. So again, we went from a situation where we're only allowed to have 1 conviction set aside to a situation where you can set aside up to 3 eligible felonies. And also, by the way, and I forgot to mention this, an unlimited number of misdemeanors, which is a pretty big deal because a lot of people they may have only 1 or 2 felonies and they may have 15 misdemeanors, driving while license suspended, for example. And they're able to get those things set aside. And the fact that they may be traffic offenses doesn't create an impediment anymore like it used to. All right, the one bad night provision. This is the provision that I referenced a little bit earlier, this was part of the Clean Slate legislation. It allows for multiple felonies or misdemeanors committed over the course of 24 hours to be counted as only one felony or one misdemeanor if they arose out of the same transaction. So in other words, when you're figuring out how many convictions somebody has, and then you're worrying about whether it might go over 3, and you know, this provision allows for a court to say, well, all of these happened within a course of 24 hours, these felonies, therefore I'm going to count them as only one felony when you're counting felonies for purposes of the limitations on how many felonies you could set aside. As with everything with Clean Slate, there are some exceptions. Assaultive convictions cannot be combined. Convictions involving the use or possession of a dangerous weapon, and convictions with a maximum penalty of 10 or more years of imprisonment. So this is really, I've seen this in action. I've seen this statute work, and I've seen this allow people to get expungements that otherwise would be barred because of the number of felonies that they have. Let me give you an example, a couple of examples of what I'm talking about here. Let's say that there's an individual who lives in a specific neighborhood. He's really angry at all of his neighbors. So he decides to go up and down the street of where he lives, and all the vehicles that are parked on the street for each residence, he scratches them pretty badly, causes some damage to them. And let's say he does that for 10 different vehicles, 10 different victims. Well, it would be, you know, if the prosecutor charged it that way, that would be potentially 10 separate convictions. Obviously, 10 convictions is more than 3, which would mean that without this provision, this person would be out of luck. But because they all arose out of the same transaction, and this person was mad about something and did it all within the course of a couple of hours one evening, they're considered one felony for purposes of counting felonies for allowing expungements to occur. This is a really big deal because otherwise anything more than 3 felonies, again, cannot be expunged. Another real life example of this that I could think of, or actually I saw this happen, is where a defendant was convicted of 4 counts of the illegal use of a financial transaction device. What this defendant did was he stole his girlfriend's credit card at 10 at night. He goes to Walmart at 11 a.m. and spends the card, or uses the card. He then goes to Meijer at midnight, uses the card. At 1 a.m., he goes to a gas station and fills up his car with gas using the stolen credit card. And finally, at 2:30 a.m., he goes to a 7-Eleven and purchases some snacks and drinks because committing crime made him hungry and tired. So he decides to stop at 7-Eleven. He is convicted of all 4 counts of illegal use of a financial transaction device. Now, normally, this would count as 4 convictions. Normally, that means 4 is more than 3. This person would be barred from getting anything set aside. But because of the one bad night provision, and because this person committed these offenses within the same 24-hour period, and it was all part of the same transaction, sort of the same crime spree, so to speak, they could be considered one conviction for purposes of counting convictions, and the defendant will be able to have all of them set aside under the new provision, under the new provisions of the Clean Slate Act, specifically the one bad night provision. The problem that I've seen is a lot of times, how does one determine whether a series of offenses occurred within 24 hours and arose out of the same transaction? I mean, this could be years down the road, and you as attorneys will probably have to turn to trial or preliminary exam transcripts, perhaps, maybe look at police reports, appellate court's opinion, and of course, talking to the applicant. You know, ask them, how did these 4 felonies happen? They all look like they happened on the same day, or the convictions occurred on the same date. Did all of these happen within a 24-hour period? And why did they happen? So that you could explain to a court that they arose out of the same transaction. The prosecutors and the attorney generals, but most likely the prosecutor, as he or she is going to know the facts of the case, may or may not agree with your assessment of the applicability of this one bad night provision. The ultimate decision as to whether convictions can be combined under the one bad night provision is made by the convicting court. So when you do these, and Robyn may talk a little bit about this, you want to make sure that you have enough information when you show up in court, or even put something in your application or append it to an application explaining why this person looks like they have 10 felonies and would normally be ineligible, but they all occurred on the same 24-hour period and with the same transaction. And so just to sort of indicate a couple of other little things about one bad night provision, the question has arisen a number of times: who has the burden of proof? In other words, when you show up in court to do an expungement, who has the burden of proof? Who has to show that these things arose out of the same transaction and within the same 24-hour period? The statute's not clear on this point. However, my experience has been that generally the courts will turn to the applicant and make them explain why they think the one bad night provision applies. So as attorneys, the kind of things that you're going to want to do is maybe doing a memorandum ahead of time explaining how the one bad night provision applies to the applicant and appending it to the application, or have the applicant do so. At a minimum, when you show up for the hearing on the expungement application, be prepared to explain to the court how the one bad night provision applies. What do you not want to do? Expect the court, the prosecutor, and/or the AG to figure out whether this provision applies. You should be prepared with facts that you can back up, because like I said, even though the statute doesn't talk about who has the burden here, my experience has been that mostly most courts have been putting that burden on the applicant. Now, the other thing that one of the things that the Clean Slate Act changed was the waiting time for filing an application. And if you recall, when I was talking about the original versions of the statute, everybody had to wait for 5 years, regardless whether it was a misdemeanor, whether it was a serious misdemeanor, whether it was a felony, it didn't matter. The Clean Slate Act recognizes that there are situations that are different, that the waiting period should not be the same for all types of offenses. So if you have more than one felony that you're trying to set aside, you have to wait 7 years. If you have one felony or one or more serious misdemeanors, and the definition of that is on this slide, you have to wait 5 years. But if you have one or more what I would call regular misdemeanors, you only have to wait 3 years. So whereas it was everybody had to wait 5 years before, now it's broken down into a tiered system where more than one felony is 7 years, one felony or a serious misdemeanor is 5 years, and then any other kind of misdemeanor you have to wait 3 years. Now, here's a real sticky point with the Clean Slate Act, and I think there's going to have to be some changes made to this statute, because I think there's something unintended that happened when this statute was drafted. What happens if the applicant was convicted of another offense during that statutory waiting period of either 7 years, 5 years, 3 years? The amendments to the expungement statute indicate that if this happens, the applicant is outright barred from setting aside the earlier conviction. That was not part of the expungement statutes prior to April 11th of 2021. There was no requirement that you be conviction free during the waiting period, during the applicable waiting period. So this is one way in which the Clean Slate Act is actually tougher on applicants than prior versions of the statute. I don't know if the legislature intentionally did that, whether it was a mistake, whether it was something that was left in that should have been taken out. In any event, there's some movement among different groups that are dealing with the state legislature to remove this language in the amended expungement statutes that causes this to happen. So we're going to kind of have to wait and see, because this has created a pretty significant problem for a lot of applicants.
Now, what do you do as an attorney if you get an applicant who finds herself in this situation? Well, first of all, don't file an application to begin with, or withdraw one that has been filed. Because remember, the part of the statute that says that you have to wait 3 years if one is denied, that's still in the statute. So you got to be careful. You don't want to file an application that you know is going to get denied, and then you have to wait 3 years, even if the statute changes. So that wouldn't be good. There's been a couple of solutions that have been discussed to this, and a couple of lines of thinking about this waiting time problem. One solution that has been suggested is that assuming that the conviction that occurred during the waiting period is expungible, the applicant should be advised to wait the applicable time for that offense, for that conviction, file an application to set aside that conviction, get it set aside, and then once that's done, go back and file an application to set aside the earlier conviction. That's one way that some judges are allowing people to get around this problem. There's also another train of thought. It's not on this slide, but there's another line of thinking about this, that when you have a conviction during a waiting period, that it merely restarts the waiting period clock. So if you have a conviction during a waiting period of 3 years, you have to wait another 3 years in order to get the earlier conviction set aside. Is that the correct way to do this? Is this thing about getting the earlier one, the later one expunged first and then go back and do the earlier one? Is that the proper way? We don't know. In my opinion, that provision about having convictions during the waiting period needs to go. And I think it will eventually. I think there are enough cases where that's becoming a problem that the legislature is going to act at some point and is going to fix this. But in the meantime, it's a problem, unfortunately, for a lot of applicants. Another key feature of the Clean Slate Act is about misdemeanor marijuana expungements. And this is a very interesting part of the statute. And there are really some significant differences between applications to expunge misdemeanor marijuana convictions and applications to expunge all other convictions. When you try to expunge a misdemeanor marijuana conviction, it's a much, much easier process than when you try to expunge any other type of conviction, because a lot of the steps that you have to take, which Robyn, I'm sure, will be talking about, in order to expunge a conviction, you don't have to do when it's a misdemeanor marijuana conviction. You still have to attach a certified copy of the relevant misdemeanor or ordinance conviction to the application. But here's the things you don't need to do. You don't have to wait any period of time before filing. You don't have to get fingerprinted and obtain a criminal history report. You don't have to have a notary sign the application. You don't have to serve the state police or the attorney general. You don't have to show up for a court hearing unless the prosecuting agency challenges that it's actually an applicable, eligible marijuana misdemeanor conviction. And there's no need, unlike the current version of the statute, to demonstrate what the applicant has done since the date of his or her conviction, or for a judge to make any findings concerning the public welfare. So it is much, much different, and it's much, much easier. There's a 60-day waiting period. Once the application is filed, it's not that you have to wait 60 days to file it. Once you file the application, there's a 60-day waiting period that would allow the prosecutor to oppose it if the prosecutor believes that it's not truly a misdemeanor marijuana conviction. For example, if somebody's trying to expunge a felony marijuana conviction, those are not obviously applicable, at least under this provision of the statute. But if the prosecutor doesn't do anything, doesn't respond, the court can act on an application to set aside a marijuana conviction. If there's no opposition filed by either the AG, well, it wouldn't be the AG, it would be the prosecuting agency, the court must grant the application within 21 days. So it's kind of an expedited process that moves it along. So If there's no response from the prosecutor challenging that this is an applicable marijuana conviction, misdemeanor marijuana conviction, it's going to get expunged. It's automatic, pretty close to being automatic. Couple of things about misdemeanor marijuana expungements. The one thing that you have to explain to clients is that applicants may not thereafter seek resentencing in another criminal case saying, well, when you sentenced me for this other offense, you considered this misdemeanor marijuana conviction. You're not able to do that. Or if it changes the sentencing guidelines for another case, that's not something you can go back once you get the misdemeanor marijuana conviction expunged and say, hey, that prior sentencing is wrong because the PRVs would be rescored. And the trial court considered that misdemeanor marijuana conviction in sentencing me. Same thing for an applicant who gets a misdemeanor marijuana conviction expunged. That does not entitle the applicant to the return of any fines, costs, or fees, or anything that may have been forfeited by the prosecuting agency or any police agency as a result of the conduct that led to that conviction. So a couple of limitations on it, but again, much easier process than was in effect previously that is in effect for non-misdemeanor marijuana convictions. In other words, all other types of convictions. Now, a couple of things are coming up in the next couple of years, and these will be my last couple of points before I turn it back over to Robyn. First-time drunk driving offenses, beginning in 2022, February of 2022 specifically. In this year, 2021, Governor Whitmer signed legislation that permits the expungement of first-time operating while intoxicated convictions after a 5-year waiting period. The statute specifically talks about what that means, operating while intoxicated. It basically means operating while intoxicated on alcohol, controlled substances, whatever it may be. It doesn't necessarily have to be alcohol. The effective date of this legislation is February 19th of 2022. So in other words, applicants really shouldn't be filing applications until just before that date or on that date. Another little key provision of this is that when a court is deciding whether to grant an applicant's request to expunge a first-time OWI conviction, the court can consider a number of factors, including whether the applicant benefited from rehabilitative or educational programs, and whether the applicant voluntarily availed himself or herself of such programs before sentencing. Now, one question that's come up, and it's a very interesting question, and I'm curious to see how this is going to pan out. There's two lines of thinking about this. Will an applicant always be able to expunge their first drunk driving offenses, even if they've got a second, third, fourth, or fifth? There's one line of thinking that says, well, you can always expunge your first one. There's another line of thinking that goes that if you have more than one, you're categorically barred. Do I know what the right answer is to that? I don't. I think we're going to have to see how judges treat that circumstance and how they address a statute. This may be something that will need a statutory fix, just like the provisions having to do with the waiting periods and having crimes committed during waiting periods. The other exciting thing that's coming up, and no earlier than 2023, is what's called automatic expungements. And under this new automatic expungement procedure, what now requires action on the part of an applicant, for example, the need to file an application to expunge a conviction, will be rendered unnecessary for many types of convictions. Not all convictions, but many types, after a specific waiting period. 7 years for most misdemeanors and 10 years for felonies that can be expunged. So this is really exciting because, as I indicated earlier when I was talking, 93 to 94% of people that are eligible for expungements don't actually seek an expungement. So here the state will be doing it for them without them even having to do anything. The unfortunate thing is that the new laws give state, it's not unfortunate, it's the reality of the situation. The new laws give state agencies until 2023 and possibly longer to develop and put into place systems for automatic expungements. I mean, it may sound like an easy thing to do, but it's going to involve a lot of new computer systems being designed. The MSP is going to have to be involved. The Michigan Department of Corrections is going to have to be involved. They're already working at a breakneck pace to try to make this deadline of 2023. I think they will. I think they'll be able to figure out how to do this by 2023. Now, I always tell applicants and attorneys that I speak with, what do you do if you have a situation where an applicant is currently eligible, but they have to file an application? Should they wait until 2023 for the automatic expungement provision? My answer to that question always is, if you're eligible now, go for it now. Don't wait until 2023, because it's very possible, although not highly likely, that this could extend into 2024 or 2025. So if you have somebody who's eligible now under the current process, even though they have to file an application to leave for application to set aside a conviction, to expunge a conviction, go for it. Do it that way. Don't wait until 2023 or later. Take advantage of all the benefits that the Clean Slate Act offers now rather than wait. Okay, I know we're going to have a question and answer session at the very end of this, but in any event, if you would like to contact me, if there's questions that are not answered during the Q&A session that I'll be sticking around for, my email address is pallasj, PALLASJ @michigan.gov, or you can call 517-355-7650 and ask for me. There's also Attorney General Dana Nessel has a web page for expungements, which gives a lot of helpful information. The website for that web page is mi.gov/AG. So with that, I'll turn it over to our other speakers for the evening. And I'll look forward to hearing questions and concerns that everybody has at the end of all of this. Thank you.
Thank you so much, John, everybody. At this time, I'm going to we're going to move right along and introduce our wonderful next speaker, who we all know as Robyn McCoy. And she is the current president of Black Women's Law Association of Michigan, who is sponsoring this event. Robyn is an attorney, educator, and legislative assistant. She currently is a lecturer at Eastern Michigan University in Ypsilanti. She was born in Ann Arbor and raised in Ypsilanti, Michigan. She graduated from Father Gabriel Richard High School in Ann Arbor, and she graduated from the University of Chicago. She graduated with honors from the University of Chicago in 1996 and received her JD from the University of Michigan Law School in 2000. She served as a congressional page for the U.S. House of Representatives under the Honorable Congressman William B. Ford in Washington, D.C., interned in the office of U.S. Senator Carol Moseley Braun in Chicago, Illinois, and is currently legislative assistant for the Honorable State Representative Ronnie Peterson of the 54th District. She was mentored by First Lady Michelle Obama during her senior year in college. She is the president, as stated, of the Black Women's Law Association of Michigan and vice chair of the Michigan Democratic Women's Caucus. She is a past president of the Vanzetti Hamilton Bar Association and served on the board for the Ann Arbor Ypsilanti Black Chamber of Congress. She presently resides in Ypsilanti, and she has worked as a deputy defender in the Legal Aid Defenders Association in Detroit office and a lawyer guardian ad litem, defense attorney, as stated. Currently, she also was in the Legal Aid Defenders Association and an educational advocate at the Michigan Children's Law Center in Detroit. She is a partner with the firm of McCoy and Associates, PLLC, based in Washtenaw County. She specializes in criminal defense, family law, educational advocacy, wrongful death, and personal injury cases. And currently, Robyn has received numerous awards for her commitment to social justice. She has traveled all over the state planning, facilitating, and organizing programs on what to do when stopped by the police, expungements, and how to navigate the public school system. Ms. McCoy has a YouTube channel, Robyn's Legal, and her website will provide that at the end. Thank you, Robyn.
Thank you, Delicia, for that. I don't know, I'm trying to get this. Hello?
We can hear you.
You can hear me? I don't know what's going on with the speaker part of this. Let's see if maybe if I go back, I'm gonna go back to speaker. Okay, I'm gonna go to share screen and I'm gonna pull up the PowerPoint that I put together for you guys. So let's get to that. So the expungement process, and I want to thank John for coming in and or zooming in with us. And I saw him do or I don't know if I think I was either on a program with him or maybe saw him do one. And I really liked his presentation and his PowerPoint. So I was like, oh, we definitely want to get have John come out and talk to us about the Clean Slate legislation. For some of you who may or may not know, we've been doing this programming since February in anticipation of the new legislation. I've been doing these workshops for probably about 7 years. I was recruited by Judge Deborah Thomas as I'm sure some of you in the audience that have been recruited by Judge Thomas as well to go the pandemic. It was in person where we would do the expungement forums and educate the public about the expungement laws. And I'm really excited about this new legislation because it's definitely more expansive. In the past, we would have to turn away a lot of people because they were not eligible, but now we have more legislation, so we're able to help more people. So the first thing that you do with the expungement process is you assess eligibility. That is an essential to this process. And what I do is I pull up the iChat for the person, and I'm gonna pull up, let's go to the iChat. Yeah, you have the iChat website, it's here. It's in the PowerPoint. You go into iChat, you know, if you're doing this a lot, you can create a username and password, and then you go to do a background search. You go to that page, and I want to give a shout out to Rafa Al-Shohati, who is my legal assistant on with us, and she has been helping me to do this because as I said, I'm getting a lot of calls. I mean, I don't know, we got probably about anywhere from 30 to 40 people that we're processing right now, and then we've got about another 20 or 30 that are that are calling me that are in the process of being you know, they want their records cleared. So you need to fill this out. You need to have the person's first name, middle name, last name, date of birth, race, gender. Typically, if it asks me for a reason, I put employment, housing, or other, just depending on that. You fill all of that out, make sure it's accurate. I just implore you, I say, make sure it's definitely an accurate thing, because if it's not accurate, then you're not going to get the right information. So, yep, so I'm gonna go back. Let's go back to where we were. Let's see. Okay, yeah, pull up the iChat. You also can go, you know, and I put on here, like what I do is I have people email me their register of email me their full name, date of birth, gender for the iChat. But I also have them pull up the register of action, because sometimes the iChat is not always accurate. We've been, Rafa and I have been finding this out, is that people, they may have more than what's on the iChat. So you want to go to the register of action for where you know, where the court is, where they have the misdemeanor or the felony. And for me, eligibility is key. I'm not going to take on somebody's case, whether it's pro bono or for a reduced rate, unless I know that they're eligible, because I'm like, I don't want to waste anybody's time. And sometimes if we have somebody that where there's a question, we'll reach out to the AG's office. We talk to the paralegal Dan that's there, and we'll get clarity about eligibility. And if the person's not eligible, then we won't pursue that. So then the next thing that once we pull the iChat, we'll pull the statute for each conviction, and we will assess, and I have the website on there for the Michigan legislature, so you can go on there and sometimes you can just Google it. Sometimes I just Google it. I put MCL and I Google the statute. I look at that, and then I will go and look at the Clean Slate legislation. They have let's go. I'm gonna so you can see what they have. Well, this is the legislature, so you can put the code in there and look up the actual statute, each conviction that the person has. This is the Michigan Clean Slate legislation overview, so you can go through like what John just went over was the statutes. So you can go through the statutes, the different statutes that are part of the Clean Slate legislation. You can go through that. I'm like a hunter-gatherer, so I've been gathering information as I either participate in some of these Clean Slate trainings, or I go. So I have a book that I put together. I also have a link. So if I'll give you guys my email, and if some of you want that information, I will forward it on to you, because we need more people, lawyers, law students, to do this, because we have folks that need help. There are some people that can afford to pay a lawyer, but there's that can't afford to do it. I'm processing right now probably about 6 people that are pro bono folks, and I'm just trying to help them, clear up their records so that they can, what I'm finding a lot of people they're saying is that they haven't been able to get a job. Like, they get hired onto a job, then they do the background check, and then they get denied, or they can't advance on their job. I have one client, we got her cleared, one of her records cleared, and she was talking about she was on a job where they knew about her prior record, and she had to be subjected to like sexual harassment, or they tried to do that because they knew the job. I mean, that's just deplorable that she would even have to go through that. And so we definitely we want people, once in themselves, if they've done everything, they repay their debt to society, that they be able to clear their record. So so you can look at the legislation, and I'll send you the email with that information. Client intake. Let me go to, let's see. I have a client intake form. Let's see if it's still. I am not seeing it readily. I'm gonna go, I'm gonna pull it up. Let's see if I can pull up my client intake form, so you guys can see that. Basically in the form, I'm just going through, I mean, it's the same for those of us that do criminal defense. It's some of the same things that we typically will ask. Oh, here it is. Yes. Okay. Some of the same questions that we'll ask when we're doing intake for our criminal cases. Like, so I've just name, address, date of birth, educational background, how far did you go?
I'm sorry, Robyn, to interrupt you. Someone in chat stated, and it's also on the screen, only thing that the participants are seeing is pull up the iChat. So I don't know if you're moving along in your presentation, but the only thing we can see is the iChat screen.
Oh, okay. Let me go back to, let's see, pull up that. Okay, let's see what's going on. Yeah, that is pull up the iChat, but then are you able to see the intake form now?
No.
Oh, it keeps saying it's paused. Okay. All right. I'm going to just go back. Let me I'll stick. Yeah, I guess we're having a glitch there. Okay. So I will, I can email you guys that intake form that I created. It's basically just going through the questions.
Now we are seeing more. Now it's moving.
Right. So what I will do is,
Yeah,
that's
but
any-
it didn't go to the other screen yet.
yeah, yeah, I don't know why it's not, but okay, so it keeps saying something about pausing, but yeah, so, but for the client, what I basically put on there is some of the things that are on the application, like I want to know, do you have any pending convictions? Do you have you applied for an expungement before? Because those are all factors that into. Do you, what do you think you have? I mean, we obviously, we pull your iChat, or I go to a register of action and look for every place that you think you have a conviction, but I just don't like surprises. I was in court the other day and somebody had 5, it wasn't my client, thankfully, but somebody had like 5 felonies, and the attorney didn't know about that. And I guess some of it didn't show up on the iChat. And I mean, that really, it sucks. It's kind of like what John was saying, is like, you want to really know ahead of time whether your client is eligible before you take the time to go in there and do the application, because if they're not eligible, then you could be denied and then you have to wait 3 years. So you really want to make sure, I mean, to me, eligibility is key. So once you determine that they're eligible, then you request a certified record of conviction. It could be the judgment of sentence. We have, Rafa and I, we've been doing that. And at first I was just going to limit it to like the Tri-County area, like Washtenaw County, Wayne, Oakland. But what we did is decided to expand it because most of the cases we've been able to
Did you eat that macaroni?
via Zoom.
Did you like it?
Everybody, please
Could you
mute
please?
Wendy.
Yeah,
That's
Wendy, could
you.
you please out? So you request a certificate of conviction, judgment of sentence, and people have been asking me as far as like the timeline, how long does this take? It depends on what county you're in. Like, we're getting pretty quick responses. Oakland is pretty quick. Wayne, I was just talking to Judge Edwards today about that. It's taking it takes time because they don't have as many. So Rafa and I, we've been calling them. Just that's what's taking more time in the process. Request fingerprints. So you request the fingerprints. One thing we learned too is that you have people for out of state that you can actually fingerprints out of state, and you can get their documents notarized out of state. So that's something new that we've learned. I mean, again, this is all like a work in progress with this. Where do you get fingerprints? You can get them at the Michigan, like I put the link down there for Wayne County, the 3rd precinct. You can call, set things up. Washtenaw County Sheriff's Department is also an option. They actually have it. There's an email that I send over to the client, and they can get them for free. And they have, Michigan Works has a grant so that they can help people process the application if they're indigent, and then they'll get a volunteer attorney to show up with them in court. And I mean, I think it'd be great if we could do that all over. But that's not, that's just, Washtenaw just has that ability to do that right now. Oakland, you can also, for the Oakland County, you can reach out to the Sheriff's Department to get fingerprinting done. So that's what, when people come to me, once we determine that they're eligible, we get, request a certified record of conviction. We have them get their fingerprinting, and, we have them get that all together. Then there's the actual application. So when we start doing the application, we draft up the application. And as I said, you go through the questions on the application to make sure that the person meets all the requirements. See, you have to specify on the application whether you're getting one or several convictions. Is it 3 felonies? Where it can be kind of complicated is like, I have a client that has multiple convictions. Well, she's not the only one. I have several clients that have multiple convictions in multiple jurisdictions. So you can't put everything on one application. You have to have a separate application for each of the. And so that's where it can factor into the cost and the time, because it's not all in one court. I mean, sometimes I have some people who have 2 felonies at Frank Murphy. You can just do one application. Sometimes spread out. Like I have one client that has 5 misdemeanors in 5 different courts. So there's going to be additional costs involved with going through that. And you know, because it's for the application, it's a $50 fee for the state of Michigan. And then you get your application together, fill it out. It has to be notarized. And then you send a copy to the court. You have to send a copy to the Attorney General's office, to the Michigan State Police, and prosecutor and the court. And then for yourself. And then, like I said, what can cause the, like, as people have asked me, what's the usual time that it takes to an expungement? It could take 3 to 5 months. Why as long as it's taking? It may take a week, not a week, it may take a month to get the certified record of conviction, depending on where you are. Like if it's Wayne County, there could be it could take a while. It's not like it used to be where you could walk in there onto the 9th floor and go pick it up. I mean, because we've got COVID. And then the state of the Michigan State Police, they're taking about 2 months to process the application. You know, we have called there to try to expedite it, but that's just the reality. It's taken 2. The AG's office, usually once we have the fingerprint history check from the Michigan State Police, they're pretty good about responsive, emailing us a response or dropping something in the mail. So the turnaround has been pretty quick there. And then you have to look at how each court handles it. Like some courts will, when you file the application, they're going to give you a date out, like months out already. Some of the courts are like, no, we're not going to do anything until we get the response from the Michigan State Police, from the fingerprint history, you know, the criminal background, and the AG's response, and then we will go ahead. We'll give you a court date. If you have a court where they give you a date ahead of time, but then you don't have all of that information ready from me and from the AG's office, then you're going to have to adjourn it, because we've had to. There's some where the whole application is ready. We have everything we need, but like with Frank Murphy, to get judges assigned so that we can go ahead and have the applications processed. I cannot express to you guys an issue about eligibility, because we had one person, I would say most of the people that we're dealing with have come back as being eligible, but we had one person that came back like he had what would be considered low felony, high misdemeanor, and they said he's not eligible. And so now we're going to have to get the prosecutor to agree to reduce or modify you know, the felony into a misdemeanor to make them eligible. And it's just really sad to see that. And it's just like when I was saying at the beginning, I was in court and I saw this gentleman that had 5 felonies, and the judge said, he's like, well, unfortunately, you can only have 3. And he said, you know, he's like, you can only have 3. And if, you know, I really would like to grant, but I can't do it. And, you know, so he's like, I'm sorry, you know, you should withdraw your application and maybe come back. Maybe the legislature will change this and you'll be able to be up for consideration. And so after you have the application, after you have everything is ready, meaning they have the response from MSP in the office, then you have the court date. So what I tell is make sure you're dressed just like we tell them for regular court. Make sure you're dressed properly, that you look nice, shirt and a tie, suit, dress. Make sure that you're very respectful to the court. What I have seen happen, typically we'll get into court. They may have me make some statements. I may make some statements about the client. Then they'll ask the prosecutor, do they object to the expungement? And, you know, they'll talk, and then they'll take some testimony from your client. And so what I've done is I'll prep the client to give testimony, like, how have you bettered yourself since since you had this conviction? You've gone to school, community service, you might have we have them write letters, get letters of support from the community. For the community service, get proof of community service. On my intake form, I have it where I'm asking about like if they've had any drug treatment and proof gotten drug treatment, proof that they've gotten mental health treatment, maybe a copy of their diploma, anything that's positive that would show the court that changed. I have had where I had somebody that eligible, the age deemed him eligible, but he had some prior contacts and the cases had been dismissed, and the judge was kind of on the border of like, I don't know if I don't really know. No, you got this stuff on here. And the prosecutor had stirred it up and everything. And I said, no, Your Honor. Okay. So he had these contacts, but the cases were dismissed. And these are really old. And he really, this is what I'm hearing from a lot of the clients. They want to be able to get jobs, to take care of themselves and their family. They want to be able to advance on their jobs. And this is an opportunity for them to do that. So thankfully, the last 3 in a row that I've been able to get the records cleared, well, now it's 4 because I just did one today. We've been having some really good success. And as I said, the AG, I look at, I do teach, I'm a professor at EMU. I look at John's office is like, they're grading your paper. So you want to make sure that your paper, you want to make sure you're on top of everything. So if you do go in and they grant, the judge grants your expungement, then you have the order to set aside and what you can do ahead of time. Like I know for Frank Murphy, they have it where you can actually draft up your own order to set aside conviction, or you could do a stipulation. Some of the judges, I know Judge Edwards will actually agree to do a stip to set aside the conviction. They'll so you don't even have to have the hearing, so that's ideal. I think that would be great if they could really streamline that. There's just certain things that if they could streamline it, it would be great. Like as far as almost like having everything online where you could just go and pull up your order of conviction. I mean, I think in Oakland you can do that, but I mean, I think that it'd be great if we had that statewide where you can just go get your certified order of conviction, some way to expedite getting your, that would be great. And then, but once they say we're going to grant it, you can also, there's a form, and I reference that. It's the, I can, if you guys, I'll put my emails in the materials. I can send you these forms that I'm talking about. So there's a form that you can set aside conviction, fill that out, you file that, they grant it, then you get that. Then you want to make sure that, I know that we know what the court is supposed to do. The court is supposed to send it to the Michigan State Police, the arresting agency, the Michigan Department of Corrections. They don't always do that. I mean, I would like to think that they do that most of the time. I'm hopeful, but sometimes, like they talk about this in the Michigan Legal Help website, they're overwhelmed. It may not happen. So I do it myself. I go ahead or I will have Rafa, my assistant, who's on here too. We go ahead and we'll send it out. And then you check the iChat after a couple of months, a month or two, to see if your client's record is clear. You're good to go. I still keep a copy. I have the client have a copy. I have a client copy in cyberspace. Anyway, you're good to go. If everything is cleared up, if it's not, you may still have to reach out to MSP just to make sure that it's corrected. I have reached out to the governor's office because there are still people that are not meeting, the requirement, they have more than 3 felonies, and so I have talked to the governor's office about, well, what about the pardon process? They said right now they're not really pushing pardons. I know she's up for re-election, but I mean, I'm not giving up on it because, it's sad. You still see people coming up to you and you want to help them, especially if it's something where they've had some things and it's like 10, 20, 30 years later. I think there should be pardons. There's been pardons, they had like 1,200 pardons, like California, Virginia, the governor's there. So I definitely that we should pursue that. And we as lawyers should definitely reach out to the governor about helping people to get pardons that are that have made positive changes in their lives. And so, okay, so that's it for me. I'm gonna turn it over to, we have Delicia and Rita, our former president, to take Q&A. And so you guys want to go ahead and you can put your questions in the chat, or well, I'm going to just, again, I'm going to turn it over to Rita and Delicia to moderate this, but thank you all for coming out. And I felt it was important to do this because I've been getting calls from people like, how do you do this, Robyn? Can you walk us through the process? And I'm like, okay, well, we need to do a training on this. And also I want to hear too, maybe some stories from folks that maybe have had some success with expungements as well. Thank you.
Well, I'll start. Hello, everyone. I'm attorney Rita White. I am the immediate president of the Black Women Lawyers Association. Attorney Coleman, Attorney McCoy, President McCoy, Attorney Coleman are doing very good work, moving the organization along very well. Okay, so first, before I ask my question, I just want to, because we're all practitioners, I just want to make sure everyone is focusing on the preventative measures to even get to the point of having individuals go through this process, the process of trying to figure out how to get an expungement, obtain an expungement, and further on as the law is moving forward in a positive manner, but we need to make sure we reduce the amount, period. So when you're negotiating and when you have clients and you're looking to negotiate potential pleas, always keep in mind, as we all know, we're experienced, always keep in mind what the actual collateral consequences of the actual conviction will be. If we're looking at to maintain our focus on hoping we can make sure we rid the client of no prior record, such as through HIDA 7411 or under any diversionary program, if you're looking to actually help negotiate a plea offer, always focus on the expungement statute, what this actual client will be eligible to expunge at the end of their term of probation. Because we want to look at ultimately our clients that are in the current to have no record, period. So we don't want clients to have to be going through this process. So make sure we're always have our eyes with the prosecutor, such as if they offer this, that, make sure that's going to qualify for an expungement. If they're not going to be able to get anything before previous, get anything that will help divert the conviction or put it under advisement immediately. So my question before we take questions, I see some questions in the question chat room, is in terms of, I'm going to direct this question to Attorney Pallas, AAG Pallas. Now the conditions to qualify for an unlimited amount of misdemeanor expungements, we all see that the serious misdemeanors, it takes some more time and there's some issues in terms of being able to have those expunged. Would those qualify in the package of unlimited misdemeanors? And if not, what specific type of misdemeanors would qualify in general to be as included and incorporated in the unlimited amount of misdemeanors that could be expunged?
Yeah, I think, thank you. That's a great question. I basically, other than serious misdemeanors, the waiting period, generally speaking, misdemeanors of any type can be set aside or expunged. It's just a matter of the difference between what's defined as serious misdemeanors and then all other misdemeanors is just how much the waiting period is. And this has been one of the great features of the Clean Slate Act is that, before, under the 2014 amendments to the statute, you could only expunge up to 2 misdemeanors. Now it's unlimited. And there are some people that just, like I said, they have things like driving with a license suspended, things like that are just really minor types of offenses. But under the versions of the statute that existed previously, those particular offenses, if there were more than 2 of them, or even 1 of them, if you go back even further, that's it. The person wasn't eligible for anything. So other than the waiting period, I believe that all the misdemeanors can be set aside.
Okay, thank you. Well, there is a question of, please clarify how and where to obtain a certified copy and conviction and where to obtain fingerprints. Would you anyone like to answer it, or I can answer it, but Delicia?
Robyn or John?
Attorney Pallas,
Yeah,
but-
I mean, yeah, where you can get the certified, as I put in the PowerPoint, it's the certified record of conviction or judgment of sentence. You send a request to the court where the conviction occurred. So you put a request in writing. I mean, what we have, I don't know if Rafa is still on here, my assistant, but we just will call the court ahead of time and say we need the judgment of sentence, and we'll ask how much does it cost, and we'll just do a cover letter requesting that with a check and send it over to them. Oakland County is pretty cool because Oakland County, you can go online and request it and get it in the mail. You can, Washtenaw, you can pay on the phone, and they just shoot me a copy over in a couple of days. So that's, and then for fingerprinting, the state police. So you want to look at, if it depends on what city you're in, you want to reach out to that local police and say, are you doing fingerprinting? See if they're doing it. If not, you want to see, does the county sheriff, are they doing it? With COVID, some people time limitations of when they're doing it. There also are some agencies that do, because I am aware of, I've had a couple of clients that have gone to some of the private agencies as well.
Currently,
I'm sorry, I just realized I misspoke. There are a couple of misdemeanors that can't be set. For example, I mentioned earlier, the 4th degree criminal sexual conduct. Technically, that's considered a misdemeanor. So anything after 2015 that's a 4th degree criminal sexual conduct cannot be set aside. Also, there's arguably a provision that says that not more than 2 convictions can be for an assault crime. That arguably could include misdemeanors, but other than, I think, those couple of exceptions, I think the vast majority of misdemeanors can be set aside, and the only difference is the waiting period of time if it's a serious misdemeanor. So I apologize for that.
thank you. Is there any other questions at this time? We don't see any in chat, but if you put your hand up on your name or section, we'll gladly call you. Any other questions? I have a question in regards to just recently, one of my clients, we were trying to go through one bad night and in Oakland County, and he had a possession with intent to deliver, obviously 20 years, a CCW, and a felony firearm. So we couldn't go through one bad night. Do either one of you guys have a suggestion? Because literally I had to put all as separate felonies as opposed to just one felony. Any suggestions?
I think that's probably the way to do it. I mean, and if I'm not mistaken, I don't know that a felony firearm, I think firearm offenses may not be eligible to set aside under one bad night. Any conviction that involves the use or possession of a dangerous weapon is something that can't be.
Yeah, that's my understanding as well.
Yeah, but aside, from that, I think you did it. I think that's the correct manner in which you handled that. The one bad night provision ends up being something that, it's both a curse and a blessing, and I've actually and it's mostly a blessing. I don't want to make it sound like it's a bad thing, but at the same time, there, especially when there's applicants who are pro se and they're appearing before a court and they don't even realize or understand what that means exactly. And what we try to do, and sometimes when the Attorney General appears, or even the prosecutors, or even the judges that I've seen, they will try to elicit from the applicant, it looks like you have a bunch of convictions that occurred on the same date, or at least convictions that occurred that you were convicted of on the same date. Try to elicit from that applicant whether or not any of those convictions might fall within one bad night.
And that kind of generally goes, I guess, to the entire Clean Slate Act. It's wonderful and as great as it is, it's more complicated. I think there's no doubt about that. And I think it makes it more difficult for pro se applicants in many instances, especially if they're trying to figure out whether they have an eligible conviction, whether one bad night applies, whether the waiting periods apply. For attorneys and organizations that provide legal assistance to applicants becomes so important because, you know, as great as the new Clean Slate Act is, it is more complicated. It's harder for pro se applicants a lot of times to figure out. And I think the role of attorneys and organizations that help on a pro bono basis or otherwise that help applicants are invaluable for helping applicants maneuver through this process because it quite frankly isn't easy.
And thank you, John. We do have one more question in the chat. Rita?
Yes, we have a question. Good. Okay, can you please go over the statutory requirements for starting the expungement process for individuals who otherwise qualify but are imprisoned after sentencing?
It's the same time period as, well, John or Robyn.
Yeah, I think if I'm understanding the question correctly, the waiting period doesn't start to run until the person has either been
Completed.
from prison or jail or has been the parole is over. So you know, obviously, unfortunately, if someone's currently in jail or in prison, they're going to be in the waiting period will not even have started to run. So they're going to have to wait until after they're released from prison for the statutory waiting period to begin, unfortunately.
Delicia, there's another question.
Okay, and that also includes, obviously, it's essentially completing your sentence, whether it's probation, parole, jail, all of that. You have to
Absolutely.
complete that before you can start counting the waiting period. Given how long the MSP is taking to complete the background checks, can a judge set aside a conviction before a letter from the AG's office under this statute? No.
I think
The answer to that.
Yeah,
Oh, I'm sorry, go ahead.
Okay, well, I was gonna say, most of the courts have said they want the MSP response, they want the AG's letter. I think that maybe in a limited situations, the judges would do that, but most of the, I wouldn't, I'm not, if I don't have MSP and a response from the AG, I'm not gonna even go there. Because you wanna make sure that they have all the information that they need, and you don't, I mean, if a judge were to grant it, you don't want the prosecutor, to appeal it. And so I wouldn't go forward without the response from both the the AG's office. But I think, I'm trying to think if we've had anyone's, yeah, I don't know. I mean, well, John, what are your thoughts on this?
Yeah, actually, in terms of the Michigan State Police report, the statute prohibits the court from granting an expungement until the completion of that report. Now, in terms of the AG's response, there isn't something that specifically says that the AG response has to be in before they grant the expungement, although I think, you know, traditionally, courts wait for the Attorney General's response until deciding whether to grant an expungement. But the only statutory prohibition is if there's been no state police report produced and sent to the court cannot grant the expungement until they get that report.
Thank you. One other thing, there's no more questions in chat. If you guys could touch on just quickly in regards to the part of the statute where you can actually have a complainant or a victim come and request or object to the expungement and the basis of that. I've had it only happen once, but I don't know if anyone else has had it.
I've had it, well, it was Clean legislation. We had the mom, they reached out to the mom, and But the dad had talked to her because he basically explained to her, he was the taxi driver, and he said, if you agree with this, then I'll be able to get a higher paying job and I'll be in a better position to pay for child support. So I have had that hearing, the expungement. They did have the mom had opportunity to weigh in, but it wasn't a negative scenario. We were still able to get the expungement granted. I could see, just from what we see in court every day, for those of us that are doing criminal defense, that you might have a toxic situation. So that's why I encourage clients to get letters, make sure you have a positive support system to deal with that type of scenario.
Yeah, I thought Robyn is completely right. I mean, because there are certain offenses when somebody moves to set aside or expunge a conviction, that the victim has the right to notification. So the prosecutor has to notify them, if they can find them, of the pending application. And I always try to tell attorneys, you may want to prepare your client if it is an offense where there was an assaultive offense or a victim that was very offended by what happened, that there's always a possibility that a victim may show up and speak. So Robyn's point is very well taken. I think it helps immensely to come into court ahead of time, or even attached to the application, letters of support, affidavits, whatever it takes, to really prove to the court. Because one of the things that still exists in the statute is that the applicant has to show what they've done since the date of their conviction, and the court has to find that it's consistent with the public welfare to set aside the conviction. So, and that burden will generally sit with the applicant. And unfortunately, it's the kind of thing that sometimes gets forgotten, because the scale form for applications doesn't even refer to that in terms when the applications are being filed. So a lot of applicants don't realize that's something that they have to address. And another thing is to advise applicants, the court may ask you some questions. The court may put you under oath. The court may do a whole lot of things. The applicant shouldn't expect that they're going to walk in there and not have to say anything or explain anything. It can be a situation where a victim shows up that it's even more, particularly, especially if the victim's opposing it, it's important for the applicant and for the attorney to be totally prepared to deal with that.
Right. I've explained to clients that this is a privilege. It's not just because the law is in place doesn't mean it's automatic that the judges are going to grant the expungement. So you need to be very humble, dress appropriately, speak respectfully to the court. Just try to do all that you can to help the attorney, if you have an attorney with you, to make sure that you get this conviction or conviction set aside.
So as we're coming close to wrapping up this great presentation, very informative, I do have a question regarding juvenile convictions. Now, the statute doesn't specify juvenile versus adult convictions regarding expungements. Now, is there any difference in the procedure or process? Do juvenile convictions apply to the same statutory process that basically applies under the statutory code for adult convictions? And then it's a two-pronged question. If, of course, a juvenile can proceed with an expungement, where can they proceed? Where can the attorney proceed with filing? Would it be at the juvenile courthouse, or would they have to contact a different court jurisdiction to proceed with the process?
I can start with that. I mean, I know I have done, we've done a couple trainings on with the juvenile court or the juvenile. I know they say it can be a year after the adjudication, and the client needs to be 18. I know that you have to look at whether they have adult convictions, because the last one that I was pulled in they were saying that the person had to get their adult convictions cleared under the clean slate in the new legislation before we could do the juvenile offenses. So you definitely want to look really closely at that, at the juvenile application, but that it's handled through the juvenile court.
Thank
I agree
you.
with everything Robyn said there.
Thank you.
Thank you. At this time, we are going to thank our panelists. It's 7:32, actually, and we see no further questions.
Oh, I do want to say that we said this was ICL credit. So the ICL
CLE?
word is, yeah, this, yeah, I'm saying ICL. I have ICL on the CLE is, so it's BWLAM. I'm in the chat, expunge, for those of you that are seeking ICL. So yep. And I definitely want to thank you all for being here, and especially thank John for coming out, and Delicia and Rita. And then I did see we had our Wolverine bar president, Kim, came through. I don't know if she's still here, but we want to thank Wolverine Bar for spreading the word about this. And you know, I look at this, this is like to me, it's like a ministry. That's why I have to tell my dad, and fusses at me because he's like, you need to be charging more for this, you know, whatever. But this is about redemption. This is about helping people. I felt the need to specifically do this training because we want to recruit more lawyers, law students. You know, we have been doing these fairs and we have helped people. I've recruited folks. I've done some pro bono cases myself, and I still have, from April, I still have some folks who need help in Ingham County and Macomb. So that's why I'm recording this. I'll be sending this out to Macomb. Again, if any of you are out there are so inclined to help people, we've got about 8 left over from our expungement fair that we did in April, and we've been asked to do one in Inkster in February from Judge Karen Braxton. So we definitely want to help people. I mean, and knowledge is power. So yeah, I want to thank you out. And yeah, shoot me an email if you want the slide, and or we'll send out the recording as well. I don't know, Delicia, Rita, did you guys have anything else to add?
Well, I just had a question in terms of the CLE. Who can we report this information to obtain a certificate for proof of attendance for people who would like to get credit?
It's the same form. You know, I know that that Kristen Lavoie sends out. You just put it under other, and then you can just put, yeah, you can do it that way. And
Great.
then because Kristen knows about it, so if you have any questions, she can call me or whatever. But yeah.
Thank you.
And just to remind everyone about the Black Women's Law Association Holiday Bash coming up, please get your ticket now. It's on our website and various other social media. So please join us. It will be awesome.
Yep, it'll be virtual. So, all right. Well, thank you, everyone.
Also, the Washtenaw County Bar Association and the Women Lawyers Association of Washtenaw County is holding a barn bash holiday event this Saturday, 6 to 10 p.m. Check out the Washtenaw County Bar Association website for the contact information, goods, dry goods, donations. That's what we're putting forth towards several organizations, nonprofit, to donate to people that are in need. So come and join.
And Rita will be singing with the band there too. So yes. So yep. Okay. Well, you guys all have a blessed evening and stay safe. Thank you, John.
Thank you,
Thanks for
John.
inviting me.
Thank you, Robyn.
Good night, everyone. Thanks.
Thank you, Rita. Bye-bye.
Bye-bye.
Thank you, everyone.